So the title of this presentation is, Hey, do you have a minute? And it was designed for small businesses and focuses on the differences between FMLA and the Connecticut Paid Leave Act. So our agenda, we're going to talk about the Connecticut Paid Leave Program. We're going to talk about FMLA, which stands for the Family and Medical Leave Act, versus Connecticut Paid Leave, how they're different and how they work together. We'll talk about implementing the Connecticut Paid Leave Act, implementing Connecticut FMLA, and we'll give you some additional resources as well as leaving time for Q&A, as I mentioned. Just a brief introduction for myself. As I said, my name is Jessica Vargas. I'm the Chief Marketing and Communications Officer at the Connecticut Paid Leave Authority, and I have a background in broadcast media, marketing, and communications. For about 15 years, I worked in that field. And I am a lifelong Connecticut resident. I have a bachelor's degree in advertising and a bachelor's degree in Spanish. So first, let's talk a little bit about the Connecticut Paid Leave Authority. The Connecticut Paid Leave Authority is the quasi-public agency that oversees the Connecticut Paid Leave Program. And we have 5 key areas of responsibility. The first is outreach and engagement. So making sure that everyone who's impacted by the Connecticut Paid Leave Program and law understands both their responsibilities and what that provides to them. We develop the policies and procedures needed to run the program. We establish the trust fund contribution rate, excuse me, and receive contributions. It's important to note that the maximum rate is established by the statute, so we cannot increase that rate. We also approve and audit private plans. That is for folks who would like to opt out of the public plan and instead have a private plan. And there are certain specifications. So the private plan must be at least equal to the provisions of the public plan. And lastly, which we're very focused on right now, we administer claims for paid leave benefits. Just a review of some key dates. So November of 2020, employer registration opened. We began, we asked that employers began deducting contributions from worker wages in January, on January 1st of this year. And the deduction is 1/2 of 1%. In February, we began accepting private plan applications. And quarterly, the contributions from employees are due to the Paid Leave Authority. There is a 30-day grace period at the end of each quarter. So for example, first quarter payments were due by April 30th, and so on and so forth. Just about 2 weeks ago, on December 1st, we began accepting applications for absences that will be happening on or after January 1st. And on January 1st, benefits will become payable. Let's talk a little bit first about who's covered by the Connecticut Paid Leave Program and who is not. So employers who have 1 or more people working in Connecticut are covered by the plan, and that does include nonprofits and private sector employers who have a unionized workforce. There's a special note for sole proprietors. So sole proprietors or self-employed individuals are not obligated to participate in the program, but they may opt in if they would like to. If they do opt in, they have to remain in the program for a minimum of 3 years, and they would contribute at the same rate as any other employee, so 1/2 of 1% of their self-employment earnings. We do have a few exceptions as to who is not covered by the plan. That includes employees of the federal government, employees of the state of Connecticut, except as to covered public employees, which I'll speak about on the next slide. We have the same rule for municipalities and local or regional boards of ed. So they are not covered unless they have covered public employees. And employees of non-public elementary or secondary schools are also exempt. Other exemptions include railroad workers, individuals who may live in Connecticut, but they're employed by the government of another state, employees of sovereign nations, which includes Foxwoods and Mohegan Sun, employees engaged in interstate commerce who work in Connecticut but do not live in Connecticut, so they don't pay income taxes here. And lastly, spouses of active duty military members who continue to pay taxes in their home state instead of the state in which their spouse is deployed. Now, I mentioned covered public employees. So what does that mean? Covered public employees, as far as the state of Connecticut goes, that is non-unionized employees who work for the state of Connecticut. Unionized employees who work for the state may collectively bargain to be included in the program, and then they would be covered. And with municipalities and local or regional boards of ed, if the unionized employees of either of those groups collectively bargain to be included, then all employees, both union and non-union, would be covered. And you can see down at the bottom of the slide, we put the definition of municipality. It's a very broad definition, so it includes not only cities and towns like you would normally think of, but also things like departments of health, excuse me, housing authorities, tourism districts, and more. Now, as I mentioned, sole proprietors and independent contractors are not required to participate in the program, but they may opt in if they would like to. If they choose to enroll, they do have to remain in the program for a minimum of 3 years. And as mentioned, they would contribute 0.5% of their self-employment earnings, so contribute at the same rate as all other employees. If there's a sole proprietor who also has employees, even if they choose not to participate for themselves, they do have to take those deductions from their employees and remit them to the paid leave authority. And if someone receives a W-2, they are considered to be an employee under the law, even if they're the owner or the officer of the company. And in that case, they would be required to participate in the program. As you've heard me mention, the contribution rate is 0.5%. Contributions are post-tax, and they are based on the employee's wages as they are calculated for FICA purposes. Contributions are capped at the Social Security contribution limit, which is currently just shy of $143,000. And so that works out to be $714 per year. So even someone who is earning above $143,000 or $142,800 would not contribute more than that $714 per year. So now we'll talk a little bit about FMLA, or the Family and Medical Leave Act, and how it works with Connecticut paid leave, but also the distinctions, because they are two separate laws. So FMLA, Family and Medical Leave Act, has been around since the 1990s. There's both a state version and a federal version. And that law provides job protection when an employee needs to take time away from work for certain qualifying family or health reasons. So that might be if someone is going on maternity leave, having a baby, if they need to take care of a family member. We're going to go through the reasons, but that law, as I said, has been around for quite a while, and that provides job protection. However, it does not provide any sort of income replacement when that person is away from work. So employers are able to adopt policies to provide for income replacement, but there's no requirement for them to provide income replacement under FMLA. So some employees might provide certain forms of PTO. They might provide a certain length of time for paid maternity leave or parental leave, for example. And they may also require or permit their employees to use any of their accruals, so their sick time, their vacation time, or any other PTO. We really want to make sure that you come away from this webinar with the knowledge that Connecticut FMLA will change pretty significantly starting in January of 2022. So here are the changes. There will no longer be any hours worked requirement for eligibility under Connecticut FMLA, so for the job protection portion. Right now, the requirement is that someone must have worked for 1,250 hours to have that job protection. That requirement will go away. Currently, job protection does not come into effect until after 12 months of employment. That will change, and it will come into effect after 3 months of employment. Probably the biggest change is that right now, Connecticut FMLA only applies to businesses with 75 or more employees, and that will change to businesses with 1 or more employees. So we understand that there's a very large segment of our small businesses in the state that have probably never had to deal with FMLA before, that now will need to offer that job protection to employees who are taking leave for qualifying reasons. There are also some expanded reasons for leave, which includes a provision for family violence leave. And there's also an expanded definition of family, which we'll review. So the The act that changed the Connecticut FMLA with these different provisions that I've just reviewed also created the paid leave portion, so the portion that provides income replacement. But again, they're two separate laws. So I just reviewed this, but just to see it in a sort of side-by-side comparison form, current FMLA laws and then FMLA starting next month. Again, will now apply to businesses with one or more employees. The job protection will attach after 3 months of employment. There will no longer be any hours worked requirement. And then another change is the length of time that someone can take job protected leave. So currently it's 16 weeks of leave in a 24-month period for all reasons with the exception of military caregiver leave. So leave taken for an employee to care for a military family member that was injured during active duty. And that provision is 26 weeks of job protected leave. Starting in January, the change will be that leave can be up to 12 weeks in a 12-month period for all leave reasons. The military caregiver leave portion is not changing. That will remain at 26 weeks for job protection. And there will also be an additional 2 weeks of leave available for incapacitation during pregnancy. Another important change is that currently, the employer can require their employees to use all of their accrued PTO if they're going out on leave in order to be paid. That is changing so that the employer will still be able to request or require that an employee uses accrued PTO, but they cannot require that they exhaust it any longer. So they must allow them to retain up to 2 weeks of accrued PTO. So for example, if an employee is going to be going out on leave, their doctor tells them they need a surgery, they're going to need 4 weeks out of work to recover, and the employee has 4 weeks of accrued PTO. Currently, the employer could say, hey, you've got 4 weeks of accrued PTO. If you want to get paid while you're out on leave, you need to use all 4 of your weeks. Starting next year, they'll be able to say, you use 2 of your weeks, but you have to let them keep the additional 2 weeks to use at a later time. So now, what about Connecticut paid leave? How does it interact? So Connecticut paid leave provides the income replacement portion, but it does not provide job protection. Connecticut paid leave, we often use the acronym CTPL, and we use that to refer to the statute itself, so the Connecticut Paid Leave Act, the program, and also ourselves here at the authority. So the Connecticut Paid Leave Act created a source of income replacement benefits. But again, at the risk of sounding like a broken record, it does not provide job protection. So anytime that an employee comes to you and indicates that they're going to need time off from work, you have to consider whether they would be eligible for job protection under FMLA, as well as for income replacement under Connecticut paid leave. You may also hear this referred to as PFML or paid family and medical leave. We try to use CTPL just to have a stronger distinction between that portion of the law and then the FMLA law. So let's take a look at the qualifying reasons that someone can either apply for job protected leave under FMLA or for benefits under Connecticut paid leave. And that's why it's so difficult to talk about one without the other, because the reasons that someone might qualify for job protection are also the reasons that they may qualify for income replacement under Connecticut paid leave. The first is medical leave, and that would be leave taken by a worker to receive treatment for or recover from their own serious health condition. Serving as an organ or bone marrow donor is considered a serious health condition, as is pregnancy. The second type of leave is called bonding leave. This is leave that an employee takes to bond with a new child that has entered their home through either birth, adoption, or foster care. Both mothers and fathers can take bonding leave. And bonding leave can be taken at any time within the 12 months following the child's entrance to the home. The third type of leave is caregiver leave. So caregiver leave can be taken by a worker to provide care for a family member who's experiencing a serious health condition. Connecticut has a provision. I believe we are one of only 2 states that have a provision for family violence leave. So family violence leave can be taken by an employee who's experiencing family violence. and it can be taken for the purposes of obtaining services from a victim services organization, seeking medical or psychological care, relocating, or attending court hearings or proceedings resulting from the family violence. So family violence, a person can use up to 12 days in a calendar year. So the length of leave for most other things is 12 weeks, but family violence leave is 12 days. And then our last two types of leave apply to the military. One is called qualifying exigency leave. So that's leave that a worker can take to engage in certain activities arising from their spouse, parent, or child being notified of a call to active duty. For example, the couple might need to see their lawyer, they might need to attend to some different financial things, perhaps they need to arrange for alternative child care because the person being deployed was the one who was primarily providing the child's care for the couple's child. Those would all be reasons that might qualify for what's called qualifying exigency leave. Military caregiver leave is the same as caregiver leave, but it is to take care of a military family member who is injured during active duty. Now, there is a special note for caregiver leave. So as I mentioned in one of the earlier slides, there is an expanded definition of family under Connecticut FMLA beginning in January. So under the law, the employee can take caregiver leave and receive paid leave benefits for any of the relationships you see listed on the screen. So a parent, a spouse, a child of any age, sibling, grandparent, or grandchild. They can also take that leave for an individual related to the employee by blood or affinity, whose close association the employee shows to be the equivalent of those family relationships. So what does that mean? That means that the employee can take leave to care for someone who is like a family member to them, regardless of if they have a biological or legal relationship. What are a couple of examples? So one might be an aunt or uncle who relies on the employee for unpaid care and has maintained a relationship that is like that of a parent and a child. A second example, and one that's probably pretty common, is an unmarried couple who consider each other their significant other. Maybe they have children together, own a home together, share finances, but they are not legally married. So this relationship by affinity means that the employee could take time off to care for that significant other, even though they're not married, if they needed to. Now we've kind of broken down what is FMLA, what is Connecticut paid leave. Let's look at the eligibility requirements for each. To this point, I haven't talked about federal FMLA other than to mention that it does exist. So federal FMLA applies to businesses with 50 or more employees. That is not changing. So if you have less than 50 employees, federal FMLA is not something that you need to be concerned with. If you have more than 50, you're probably already familiar with it. For job protected leave under federal FMLA, an employee must have been employed for at least 12 months and worked for at least 1,250 hours in the 12 months immediately preceding their leave. Again, that is not changing. Connecticut FMLA, as of January 1st, 2022, in order to be eligible for job protected leave, an employee must have been employed by the employer for at least 3 months. There is no longer going to be any hours worked requirement. And eligibility for Connecticut paid leave. So again, FMLA is the job protection, Connecticut paid leave is the income replacement. In order to be eligible for Connecticut paid leave, an employee must have earned at least $2,325 in what we call the base period, which is the highest earning quarter of the first 4 of the past 5 quarters. And that can be from 1 or more employers. So if you have a part-time employee who also has 1 or 2 other jobs, as long as the combination of wages in that base period is equal to or greater than $2,325, that person would meet that requirement. The other requirement for eligibility for Connecticut paid leave is that they must be currently employed and working in Connecticut, or they must have been employed and working in Connecticut during the 12 weeks immediately preceding their leave. If someone is a sole proprietor or self-employed individual, and they've opted into the Connecticut paid leave plan, they must also be a Connecticut resident. So in general, residency is not a requirement, with the caveat that it is a requirement for sole proprietors or self-employed individuals. Again, let's review the entitlements for these three different laws. So under federal FMLA, job protected leave, an eligible person would receive up to 12 weeks in a 12-month period for all leave reasons, except for military caregiver leave, which would be 26 weeks in a 12-month period. When Connecticut FMLA changes in January, the leave lengths will match federal FMLA for most cases. So up to 12 weeks will be available in a 12-month period for all reasons, except, as on the federal side, up to 26 weeks for military caregiver leave. And then unique to Connecticut, again, with the Family Violence Leave Act, there's up to 12 days in a calendar year that can be used for family violence leave. And there may be an additional 2 weeks available for incapacitation during pregnancy. For Connecticut paid leave benefits for the income replacement portion, up to 12 weeks will be available in a 12-month period for all reasons, including military caregiver leave. So this is an interesting distinction and one to take note of. If someone is taking military caregiver leave, they may be eligible for up to 26 weeks of job protection, but only 12 of those weeks would be eligible for income replacement under Connecticut paid leave. Under Connecticut paid leave, 12 days of income replacement can be available for family violence leave, and those additional 2 weeks of income replacement for incapacitation during pregnancy may also be available. Now, you've gotten a lot of information about the Connecticut Paid Leave Act. How do you go about implementing it? So we have kind of 4 buckets of different responsibilities. And the good news is that employers, we have tried to take on as much of the responsibility on our end so that there's not a whole lot for employers to do if an employee is applying for paid leave benefits. So first, what does the worker have to do? So we ask that they submit their application for benefits in a timely fashion. What we mean by that is if it's a foreseeable reason for leave, we ask that it's 30 days in advance. If there's a planned surgery or something like that, obviously not everything it can be known. So if it's an emergency or unforeseen circumstance, we just ask that they submit their application as soon as possible. To do that, they would create an account with Connecticut Paid Leave, provide us with the requested supporting documentation, update their account with any information about absences or other sources of income. And of course, we want them to speak to you, their employer, about the fact that they've applied for this claim. Now, the employer, what you need to do when someone applies, when they put in their application with AFLAC, who is our third-party claims administrator, they will be given a welcome packet of information. And in that is one form called the Employment Verification Form. They'll fill out their name, address, information on the top, and then they'll provide that to you. And I do have a sample in here that I'll share with you. We will ask that you fill out the remainder of that form, which asks questions about their typical work schedule, et cetera, and that you return it directly to AFLAC with the contact information that's listed right on that form. Beyond that, your other responsibilities are to notify your worker about your PTO policies. So are you allowing them to use their accrued time off if they would like to, keeping in mind that you do need to allow them to keep 2 weeks for future use. Talk to them about short-term disability if you have a policy that they pay into and how that works, and then refrain from discriminating or retaliating against the worker. At the Paid Leave Authority, in conjunction with AFLAC, we will determine eligibility. We'll review all the supporting documentation. We'll request any additional documentation if anything is missing. Based on that, we will approve or deny the claim, calculate and pay the benefits, investigate any potential fraud, impose any penalties if it's appropriate. The Connecticut Department of Labor has a role in this as well. They will hear appeals relating to the denial of claims and to penalties. So if a worker submits an application and they're denied, they automatically have the right to request a reconsideration, where we will go through again and look, and perhaps it was something like there was a piece of documentation missing, or their medical provider failed to sign the medical certification form, something like that. We can do a reconsideration and see if the decision stands or if it would be changed. If after the reconsideration, the employee still feels like their claim should not have been denied, then they would go to the Department of Labor. So I already talked through the process briefly, but just to sort of visualize it for you. Step one is the worker submits their claim. We're really encouraging folks to use our online portal, but we do also have a toll-free number that they can call in if they would prefer to use that method to submit their claim. The benefit of the online portal, of course, is that it gives them 24/7 access to their account. They submit their application. They let us know about the reason for their claim, the length of leave, the type of absence, and any other sources of income, whether that's any other jobs or other forms. Again, AFLAC will determine if they are eligible based on those earning and employment requirements. And then they will also determine if the claim is approved. AFLAC will calculate the benefits, so they will use DOL data to verify a worker's earnings in order to calculate the benefits. And then we will also issue the benefit payments. So payments can be issued either via direct deposit into the employee's bank account or through what we call a stored value card, which is essentially a Visa debit card. Benefits are issued every Tuesday, 2 weeks in arrears. So for example, if someone is approved for benefits the week of 1/2 through 1/8, they would receive their payment on 1/18. When the employee is notified of their claim being approved or denied, you, the employer, would also receive an email. And let's assume if the claim was approved, you would have the worker's name, the leave that they were taking, the start and end date of the leave, and the weekly benefit amount that they would be receiving. And then the worker is to notify AFLAC of any changes. So if their doctor says you actually need to be out for 2 weeks longer than we thought, or conversely, you can go back to work sooner, especially if they are taking intermittent leave, the worker needs to provide frequent updates about that usage because intermittent leave can be, of course, unpredictable. As I said, this is a sample of the employment verification form. I just highlighted on here a couple of pieces because we really want you to make sure that you pay specific attention to the contact information. We need a contact name, phone number, and email address for someone at the business that we can contact with any questions. Again, this is also how we will notify you of a claim being approved or denied, so we want to make sure that we have an accurate email address. In terms of the benefit payments, I used to have a slide in here that went through the very complex formula to figure out what the benefits are. And in actuality, you don't have to calculate the benefits. So we're just kind of going to give a rundown of the important highlights. For minimum wage workers, it's pretty straightforward. They earn 95% of their base weekly earnings. The base weekly earnings is, of course, in this instance, minimum wage times the number of hours that they work per week. Workers above minimum wage have a different calculation, but the important thing to know is that the maximum weekly benefit is capped at 60 times the state minimum wage. Because minimum wage is currently $13 an hour, that cap right now is $780 a week. A worker cannot receive more than 100% of their normal wages when Connecticut paid leave benefits are combined with any employer-provided benefits. Now, if a worker comes to you and they're trying to ask you how much they might be able to expect to be paid, you can direct them right to our website. We have a benefits estimator on our claims page where they could enter their pay period frequency, their gross earnings for that pay period, and then get a benefit estimation. It is a rough estimate because, of course, that number can be offset by employer-provided income replacement. But again, if you do have someone who's asking, this is a resource that you can direct them to. Now, one question that we receive a lot is, how does Connecticut paid leave intersect with any employer-provided benefits? So we've put together 4 different scenarios to help address this. The first scenario, the worker has no PTO to use at all. So they're going out on FMLA leave. They have no employer-provided paid time off or other income replacement. That's pretty straightforward. In that case, the worker can receive the full amount of the CTPL benefit for the full time that they're out on leave. The second scenario, the worker has available PTO that is equal to their regular pay. In that case, they do not have any access to Connecticut paid leave benefits because their employer provided benefits are fully replacing their income for the time that they're out. Those two, again, are very straightforward. Scenarios 3 and 4 are where we have sort of the intersection of benefits that becomes a little bit more complicated. In the third scenario, if our worker has available PTO at their regular pay that covers part of their leave, then the Connecticut paid leave benefits would start after the employer provided PTO benefits were exhausted. Again, keeping in mind that the employer now has to allow the employee to retain up to 2 weeks of their PTO. And then in the fourth scenario, the worker has PTO, but it only provides partial pay, part of their normal pay. In that case, the worker would receive benefits at the start of their leave, and the employer would coordinate the benefits to make up any wage difference. Again, important to keep in mind that the employee cannot receive more than 100% of their regular pay. Oftentimes, people ask us who pays first. Is it Connecticut paid leave? Is it short-term disability? Is it the employer's PTO? So in terms of short-term disability, that really is dependent on the way your short-term disability plan is written. In most circumstances, short-term disability is the payer of last resort. So after employer-provided PTO and any state benefits. But again, that's not universal. So we would really encourage you to look at your plan and see how it's written so that you can communicate that to your employees. What can you tell your workers now that will be helpful to them? So the first thing is, will you require or permit them to use any PTO while they're out on leave? Are there any rules about how they can use that time? So if they're taking caregiver leave, can they use their sick time or do they have to use their vacation time? And again, if you have a short-term disability policy, as I just mentioned, who pays first? Does the plan pay first or does Connecticut paid leave pay first? And then will the short-term disability policy reduce the amount it pays by any Connecticut paid leave or employer-provided PTO benefits? So that section was all about Connecticut paid leave, the income replacement portion. Now we're going to talk about Connecticut FMLA. And before I go into this, I do just want to note that Connecticut FMLA is overseen and managed by the Department of Labor. We at the Paid Leave Authority really don't have any formal responsibilities over Connecticut FMLA, but we do provide training on it simply because, as I mentioned, it is pretty difficult to talk about Connecticut paid leave without talking about Connecticut FMLA. So again, if we look at our 4 buckets of responsibilities, when it comes to FMLA claims, so for job protection, the worker notifies their employer about the need to take time away from work in a timely fashion. Again, we would ask that it's 30 days in advance for foreseen circumstances. They submit their FMLA application and they submit it directly to the employer. So it's the employer's responsibility in coordination with the employee to determine if their leave is subject to job protection under FMLA. The Connecticut Paid Leave Authority does not do that. We have no responsibility for determining job protection. The worker provides the employer with supporting documentation, whether that be a medical certification, adoption documents, military orders, depending on the type of leave. And of course, the worker has to comply with the employer's attendance and call-in policies. The employer, so one really important thing is that you have an established leave policy, including rules about PTO usage. So if you don't, we would advise that you work on that now. And there are different resources such as the Connecticut Small Business Development Center that provide free advising and guidance for businesses that could potentially help you with that. Post your FMLA posters, you process leave requests, you monitor leave usage and manage the worker's return to work and refrain from discrimination. Again, the Connecticut Paid Leave Authority has no official responsibilities related to Connecticut FMLA. That is the purview of the Connecticut Department of Labor. So they provide guidance to workers and employers about FMLA and investigate any complaints regarding denial or discrimination related to FMLA. We know that everyone is eager to receive the new documentation and guidelines from Connecticut DOL. We know that they are working on them now and they're at the point of reviewing them with different internal agencies before they can be widely disseminated. So That is coming, even though they, I believe, are still not available on the DOL website right now. Again, to visualize the process for FMLA, for job protection. The worker notifies the employer that they need time off from work. They don't need to use the term FMLA. So if the reason that they're telling you they're going to be out from work seems like it might qualify for FMLA, you need to consider if they would be, if they would in fact be eligible for job protection. So if they tell you, I need to take some time off, my mom had some serious surgery and I need to take her back and forth to doctor's appointments for the next few weeks, that should trigger for you. That might be eligible for job protection under FMLA. So then you, the employer, will determine if the worker is eligible for Connecticut FMLA. So this is not the leave approval. This is just determining their eligibility based on the requirements. So 3 months of employment with you. You have 5 business days to notify the worker of their eligibility and provide a notice of rights and responsibilities. From there, the worker will provide you with the required documentation for the type of leave they're taking. They have 15 calendar days to provide that documentation. If they tell you they're having a hard time getting some of the documents, for example, maybe their doctor's been, on a week-long vacation and they haven't been able to get the forms, you should give them a bit of extra time. Once you've had a chance to review that, you would then notify the worker if their leave is approved for job protection under FMLA. So once you have all the documentation, you have 5 business days to review it and let them know if their leave request is approved. You should also notify the worker if they are required to use their paid time off accruals, when and how they need to report in, and if they'll need to provide a fitness for duty before returning to work. The worker actually reports to you when they take leave, and you track that to make sure that they do not exceed the 12 weeks. Now, in cases of continuous leave, that's pretty straightforward, but in cases of intermittent leave, that's a little bit more tricky because, again, it's not always foreseen. So, for example, someone might take intermittent leave because they suffer from debilitating migraines. They're not going to know when those are coming on. So that's why it's really important for them to report to you when they're taking time for that reason, and for you to track that it is in fact FMLA, job protected reason for them taking time off. And then when they return from their leave, you, the employer, return them to the job they held before leave. So that's the same job, same title, terms and conditions, pay, schedule, etc. You cannot insist that they be 100% fit for duty or totally recovered. So you would want to consider ADA and CFEPA obligations. So that's Americans with Disabilities Act and the Connecticut Fair Employment Practices Act. Of course, this is not always very straightforward, cut and dried when it comes to FMLA. So some challenges with managing worker absences could be enforcing attendance and call-in policies, getting timely notice from workers and supervisors about their absences, managing intermittent leave, which we just talked about. If there is a worker who works a fluctuating work week, that could make it more difficult to calculate what their average work week is. Things that you don't necessarily have control over, like incomplete or insufficient medical certifications. And of course, managing the interaction between both the federal and Connecticut FMLA, and then any other laws that do provide job protection. In all circumstances, it is your right and responsibility as the employer to designate time off that qualifies under FMLA as FMLA. So if it seems to you like it qualifies, but the worker says, no, I don't want that to be marked as FMLA, I'm just gonna, take it as vacation time. If you know that it is an FMLA reason, make sure that you track it as such, because it provides it's protection both for you and for the worker. A quick review of the laws providing job protected leave and the laws providing income replacement. So we've talked extensively about federal and Connecticut FMLA. Workers' compensation provides both job protection and income replacement for on-the-job illnesses or injuries. The Americans with Disabilities Act applies to businesses with 15 or more employees. Same with the Pregnancy Disabilities Act, 15 or more. And the Connecticut Fair Employment Practices Act is 3 or more employees. And for those last three, leave may be a reasonable accommodation for the condition that the person is experiencing. Laws providing income replacement in addition to workers' compensation, Connecticut paid leave is the only other law that provides income replacement. So I know this is a lot of information in a short period of time. We do want to give you some additional resources where you can find more information. Our website is the best place to go. We have downloadable resources. So we have an employer toolkit. We have a human resources toolkit with more information about administering the program. We also have information that you can print out and give to your employees. So we have a fact sheet, an employee rack card, an employee rights poster. If you have additional questions, we do not have a call center, but we do have a contact us portal on our website. And the reason we don't have a call center is that it is extremely expensive. It's upwards of several $1 million per year to run. So with the contact us portal, you can write in through the website, you can send your question. And if you would like to speak to someone as opposed to going back and forth through email, we can do that. You would just indicate that you would prefer a call back, and those inquiries are responded to within 48 business hours. We also have several hundred frequently asked questions on our website and helpful videos on our YouTube page, including tutorials for how workers can submit a claim online, how can they create an account with Connecticut paid leave, and we're constantly creating new ones all the time. I'm working on one right now for the employment verification form, just to provide some clarity on how to fill that out. So those are all great resources. And with that, I will stop sharing. And I see we had a couple of questions come in. So let me see if I can answer them. So one question was, what is the new FMLA starting in January? So it's not new, it's just a change to the current FMLA, the current state of Connecticut FMLA. And the changes to review are that now companies with one or more employees will need to consider if someone is eligible for job protection under Connecticut FMLA. And there will no longer be any hours worked requirement, and job protection will attach after 3 months. I should have looked down. The next comment was that they saw it, but in any case, it's good to review. The next person asked, said they started to receive employment verifications directly from employees who are going out on leave. Will that be the process, or will AFLAC or the state be sending in the employment verification request? No, the employee will provide you with the employment verification form. So as part of their welcome packet, when they begin a claim through our online portal or when they call AFLAC, they'll be given that information. They'll fill out the top portion with their name, address, phone number, etc. And then they'll provide it to you, the employer, to fill out the rest of the information. And right on the form will be the email address and the fax number for AFLAC so that you can return it. If an employee works in Connecticut but lives out of state, are they eligible for the Connecticut benefit? If they are a covered public employee, so as long as they're not one of those exempted categories, then yes. If they work in Connecticut and they pay taxes in Connecticut, yes, they would be eligible for Connecticut paid leave. The next question, it looks like someone said I answered it. And then, if an employee is currently out on leave and the leave will continue into 2022, does the new 12-week policy apply, or are they still eligible for 16 weeks? That's a great question. That's an FMLA question. And so although I hate to pass the buck, I would advise that you contact the Connecticut Department of Labor for that, because they are the ones that oversee FMLA. And I believe that is one of the things that they are trying to address in their new guidelines. And someone asked if the slide deck will be emailed to you. It will. In, I would say, probably 2, maybe 3 days, you'll receive a link to this recording and the slide deck as well. And I believe I have answered all the questions. Thank you so much for your time. And again, I would direct you, if you have further questions, please do look into our website and use the contact us feature. We would be happy to help you. We know this is a lot of information. We know it's new, and it's a lot to take in and to implement. So we want to make it as easy as possible for you. So thank you again. I appreciate your time, and I hope everyone has a wonderful day. Take care.